Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
Were impacted by the gunfire that was happening around them and the subsequent stabbing and destruction of evidence.
Suppressor freedom lawsuit. All right, so picture this. There's this ongoing legal showdown that's stirring up some serious buzz in the firearms community. We're talking about the Suppressor freedom lawsuit, a real game changer in the fight against suppressor bans in certain states. Now let's dive into what's really cooking here. So, why all the fuss? Well, it's about challenging bans on suppressors, those nifty little devices designed to reduce the noise of gunfire.
The Second Amendment, from the day it was passed, limited the type of people who could own a gun and what type of weapon you could own.
Directly attack the issue at hand, and for me, it's very laser focused. It's violent crime in the metro.
Turns out, some states aren't big fans of these gadgets and have slapped bans on their purchase and possession. That's where this lawsuit struts onto the scene, guns blazing. Figuratively speaking, of course. Now, zooming in on the action, there are two heavyweight lawsuits causing a stir, both swinging punches at suppressor bans in Illinois. First up, we've got the Morris versus Raoul case, and then there's Anderson versus Rule case. These bad boys were filed in a federal district court in Illinois, and let me tell you, they're causing ripples in the legal waters. These lawsuits aren't just about fighting for the right to own suppressors. They're about challenging the bans that put a clamp on lawful ownership. See, in a bunch of states, including Illinois, there's this ban preventing folks from getting their hands on suppressors, despite them being legal and widely used in 42 other states. These cases are pretty darn important, because they're taking a swing at bans that don't quite match up with the Second Amendment. You know, that whole right to bear arms thing? Yeah, that one. It's arguing that these bans are stepping on that constitutional right. And hey, these aren't your run-of-the-mill legal tussles. No, sir. These cases are the first of their kind, aiming to shake things up by saying, hey, this ban on suppressors? Not cool, not constitutional.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
People are rallying around these lawsuits because they're challenging the status quo. They're saying, hey, 42 states think suppressors are all right, so why not here? It's all about standing up for what's believed to be a fundamental right, a right that's being denied in a handful of places, including Illinois. So picture this legal battleground as a way to fight for the freedom to own and use these suppressors without the heavy-handed bans. It's like the Wild West of legal disputes, and these lawsuits are aiming to carve a path toward freedom for folks who want to exercise their Second Amendment rights without unnecessary restrictions. Challenging suppressors ban. Buckle up, because we're about to dive deep into the legal battlefield that's brewing in Illinois. Two lawsuits, Morris versus Raoul and Anderson versus Rule, are causing quite the stir in a federal district court. And let me tell you, they're not your average legal scuffles. Nope, these lawsuits are packing some serious heat as they take aim at challenging suppressor bans in the land of Lincoln. In 42 states across this fine nation, owning a suppressor is A-OK.
Guns don't kill people. People kill people. Criminals, miscreants will always get their hands on guns.
Were impacted by the gunfire that was happening around them and the subsequent stabbing and destruction of evidence.
But then there are these select places, including Illinois, where bans on these noise-reducing gadgets are throwing a wrench in the works. And that's where these lawsuits step in. They're not just about fighting for the right to own suppressors. They're about challenging these bans that are blocking lawful ownership. Morris versus Raoul and Anderson versus Rule are making waves because they're taking on these bans head-on. They're strutting into the legal arena, guns metaphorically blazing, to argue that these bans are infringing upon Second Amendment rights. You know that old chestnut about the right to bear arms? Yeah, that's what's on the line here. The significance of these lawsuits can't be overstated. They're not just about suppressors, they're about setting a precedent. If successful, They could pave the way for similar challenges in other states with bans on these handy devices. They're aiming to say, hey, just because we're in Illinois doesn't mean we shouldn't have the same rights as folks in other states. And boy, are these lawsuits making some strong points. They're arguing that these bans are unconstitutional, that they're putting unnecessary shackles on law-abiding citizens who just want to exercise their rights without jumping through hoops. What's fascinating here is that these lawsuits aren't just about the present, they're about shaping the future. They're saying, hey, let's rethink these bans and ensure that our rights are protected for generations to come.
We have the third highest gun-related injuries in the country, 90% higher.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Now, the nitty-gritty of these cases is where things get real interesting. They're challenging the very foundation of these bans, arguing that they're not in line with the Second Amendment. They're saying, look, suppressors are commonly used tools, not some wild, dangerous contraptions, so why are they being banned? The hope here is that these lawsuits will serve as a wake-up call. They're not just legal battles, they're fights for fairness and rights. They're aiming to shine a light on these bans that, let's face it, seem a tad outdated in a world where the majority of states have no issue with suppressor ownership. In a nutshell, Morris versus Raoul and Anderson versus Rule are leading the charge against suppressor bans in Illinois. They're like beacons of hope for those who believe in the fundamental right to own and use suppressors without unnecessary restrictions. And who knows, their success might just trigger a domino effect, inspiring similar challenges in other states with similar bans. The argument. Illinois is stirring the pot, arguing that suppressors shouldn't get the same Second Amendment love as firearms. They're playing hardball, claiming that these noise-reducing gadgets don't quite make the cut as arms. According to them, suppressors are more like accessories, not the real deal. Their whole shebang revolves around this idea that because suppressors don't shoot bullets themselves, they're not covered under the Second Amendment's protective umbrella. They're making this distinction between what's considered a full-on arm and what's just a fancy attachment for firearms. It's like saying, sure, you've got your gun, but that silencer? Nope, not protected.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
Their playbook includes this argument that suppressors are not the kind of tools the Founding Fathers had in mind when they penned the Second Amendment. They're making this case that the amendment is all about guns, actual firearms, and suppressors, well, they're just extras, like a cool accessory you add to your favorite firearm. It's like they're trying to throw suppressors under the bus, saying they're not in the same league as guns when it comes to constitutional protection. According to Illinois, the Second Amendment is all about guns and not about these noise-muffling attachment thingamajigs. Now, this argument might sound all fine and dandy until you consider a few things. First off, federal laws actually treat suppressors as firearms. Yeah, you heard that right. Uncle Sam says, hey, these little gizmos, they're the real deal. But Illinois is out here saying, nah, let's ignore that. They're just doodads, not actual arms. Plus, let's not forget the bigger picture here. The Second Amendment talks about arms, not just guns. It's a broad term, kind of like an umbrella covering all sorts of things that go bang, or could be used for protection. Illinois is trying to narrow it down, saying, nope, just guns, please. But here's the kicker. These lawsuits are pushing back against that narrow view. They're saying, hey, the Second Amendment's not just about muskets or the stuff they had back in the day. It's about the right to bear arms, whether they're old school or the latest tech.
This rule turns law-abiding gun owners into felons is a result of unelected bureaucrats
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
So while Illinois is trying to disqualify suppressors from that constitutional protection, these lawsuits are fighting tooth and nail to widen the scope, arguing that modern tools like suppressors should also fall under the Second Amendment's protective umbrella. It's a classic clash of interpretations, and boy is it heating up the legal battleground. Judgment on the pleadings. In the legal bout surrounding suppressors, Illinois is pulling out all the stops with a move straight out of the legal playbook, a motion for judgment on the pleadings. It's like trying to end the game before the first whistle blows. This maneuver is their ace in the hole, their shot at saying, case closed, nothing to see here, before things even kick off in court. Their whole aim? To dismiss the whole shebang before it even reaches trial.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
All based on the premise that suppressors simply don't qualify as arms protected under the Second Amendment. It's like they're arguing, hey judge, we're all for gun rights and all that jazz, but these suppressors? Nah, they're just fancy add-ons, not the real deal. So how are they making this case? Well, they're taking a hardline stance, trying to convince the judge that suppressors don't fit the criteria to be considered arms under that hallowed Second Amendment. According to Illinois, for something to be covered by the constitutional love, it's got to be the main event, the star of the show. And in their playbook, suppressors are just the sidekicks, the extras that don't deserve that same level of protection. Their argument hinges on this idea that when the Founding Fathers were penning the Second Amendment, they weren't picturing suppressors. Nope, not at all. They're saying it's all about guns, actual firearms, nothing more, nothing less. It's like they're telling the judge, you've got to shoot bullets to get into the Second Amendment club. But hold your horses, Illinois. The folks on the other side of this legal showdown aren't backing down that easily. They're playing their own tune, arguing that the Second Amendment isn't just about the muskets and rifles of yesteryear. Oh no, it's bigger than that. It covers all kinds of arms, including modern tools like suppressors. So while Illinois is trying to slam the door shut on this case, the other side is like, not so fast. They're arguing that suppressors absolutely fit the bill of what the Second Amendment protects. They're saying, hey, times change and so do the tools. The right to bear arms? It includes these noise-muffling gizmos too.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
It's a classic clash of legal interpretations, a showdown between narrow and broad views of the Second Amendment. Illinois is taking a swing at ending this tango early, while the other side is gearing up for a fight, refusing to let this debate slide into a quick dismissal. So, there you have it, a legal tug-of-war over what falls under the protective wings of the Second Amendment. It's like a battle of wits, each side trying to outmaneuver the other in the courtroom. And in the end, the judge will be the one holding the gavel, deciding whether this legal show gets a curtain call or goes on to the full production. Definition dispute. The good old debate about suppressors. Are they the real deal? Arms protected by the Second Amendment? Or just fancy add-ons to firearms? This is the heart of the clash in the legal arena, where one side is saying, hey, they're arms, while the other argues, nope, they're just accessories. So let's break it down. On one side of the ring, you've got Illinois and its crew arguing that suppressors don't make the cut to be considered arms under the Second Amendment. They're painting these noise-dampening devices as mere extras, like the cherry on top of your sundae, not the sundae itself. According to them, the amendment only covers actual firearms, not these fancy add-ons. But here's where things get interesting. Federal laws have a different story to tell. Uncle Sam's legal books actually treat suppressors as firearms themselves. Yep, you heard that right. Federal laws are saying, hey, these little gizmos, they're without unnecessary restrictions. So while one side is trying to downplay suppressors as just accessories, the other side is waving the federal rulebook saying, nope, they've got a place at the firearms table. It's a classic clash of interpretations, a legal puzzle with real-world implications, all centered around this question of what suppressors truly are, mere add-ons or bona fide firearms in their own right. Impact of recent California decisions. The legal landscape is ablaze with recent events in California, where court rulings in Miller v. Bonta and Duncan v. Bonta threw a colossal wrench into certain firearm restrictions, deeming them unconstitutional. This seismic shift in California's legal terrain isn't just local gossip, it's sending shockwaves across state borders, particularly resonating in the Illinois suppressor case. In those California courtrooms, judges dropped the mic, declaring certain restrictions on firearms unconstitutional. It's like they lit a beacon, signaling a new era in the legal battle for firearm rights. But what's even more fascinating is how these California rulings are playing a role thousands of miles away in Illinois, specifically in the fight against suppressor bans. The legal maestros behind the Illinois suppressor case are pointing fingers at these California decisions, saying, hey, this is precedent, and it's got something to say about our case too. They're wielding these rulings like a mighty sword, arguing that if California restrictions got the boot for being unconstitutional, maybe, just maybe, similar bans on suppressors in Illinois should meet the same fate. Imagine it as a legal domino effect.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
Mufflers on our vehicles is because they're incredibly loud. That output is incredibly loud. The muffler helps dampen that noise. The suppressor is the same way.
The impact of these California decisions isn't confined within state lines. It's like they become a guiding light, casting a legal shadow that stretches far beyond the West Coast. The arguments made and the strategies employed in California are now finding their way into the courtroom discussions in Illinois. These rulings have become more than just legal victories. They're now critical support for other battles, including the fight against suppressor bans. They're serving as a blueprint saying, look, if these firearm restrictions in California were deemed unconstitutional, maybe the bans on suppressors in Illinois should face a similar fate. And the folks behind the Illinois suppressor case aren't shy about leveraging these California decisions. They're citing them as persuasive evidence, using them as a beacon of hope for their fight against suppressor bans. It's like they're saying, see, if these restrictions on firearms got axed in California, then perhaps these suppressor bans here in Illinois should face the same scrutiny. This isn't just a legal tussle, it's a narrative of how one state's court rulings are shaping the battle for rights across the nation. Those California cases have gone from local headlines to becoming integral chapters in the broader story of constitutional rights and firearm regulations. So as the drama unfolds in Illinois over suppressor bans, those California rulings are playing a supporting role, standing as a precedent that might just tilt the scales in favor of those fighting for their right to own and use suppressors without unnecessary restrictions. They become more than legal victories. They become symbols of hope and influence in a fight for broader rights across different states. Importance of 2A wins. The significance of victories in firearm-related cases across different jurisdictions stretches far beyond state borders. It's like a ripple effect that reverberates through the entire legal landscape. These wins aren't just isolated triumphs. They're dominoes that can potentially shape the outcome of battles for firearm rights in various corners of the nation. When a jurisdiction scores a win in a Second Amendment case, let's say a successful challenge against certain firearm restrictions, it's not merely a local celebration. It's a beacon of hope for those fighting similar battles in other states. These wins carry weight, setting precedents and creating a roadmap for other legal warriors in the broader fight for constitutional rights. Consider this: a courtroom victory in California over firearm restrictions isn't just about California. It's like a spark that ignites fires in other states, providing a foundation for arguments and strategies in cases miles away. These wins become a reference point, a guiding light that says, hey, if it worked here, maybe it could work there too. Let's take the recent triumphs in California's Miller v. Bonta and Duncan v. Bonta as an example. Those victories weren't confined to the Golden State. They've become part of a larger narrative in the battle for firearm rights. The arguments and rulings in those cases are being used as supportive precedents in fights against suppressor bans in Illinois and potentially influencing similar cases in other states.
The suppressor will reduce the muzzle flash so that they couldn't ignite those gases.
Word that Sheriff Hart is also against the new bill that was passed on Tuesday.
Wins in different jurisdictions aren't just about celebrating victories, they're about building momentum. They create a network of legal support where successful arguments and rulings in one area become ammunition for battles in others. It's like a domino effect. Each win nudges the next, influencing legal landscapes and strengthening the fight for constitutional rights on a broader scale. These victories serve as vital building blocks in the larger mosaic of firearm-related rights across the country. They're not standalone triumphs, but interconnected pieces that contribute to a tapestry of legal precedents, shaping the understanding and interpretation of constitutional rights in different jurisdictions. So when you hear about wins in 2A cases across various states, remember, they're not just individual victories, they're building blocks in a larger movement. They pave the way for challenges against restrictive laws in other areas, offering hope and support to those fighting for their rights, creating a legal landscape where each success breeds potential for broader change. Supplemental authorities. In the high-stakes legal tango of the Illinois suppressor case, the judge made a game-changing move that has tongues wagging and hearts racing. Imagine the scene. The courtroom buzzes with anticipation, and then, in a pivotal moment, the judge gives a subtle nod, signaling the acceptance of two heavyweights into the legal arena, Miller versus Bonta and Duncan versus Bonta, the supplemental authorities. These decisions aren't just pieces of paper, they're power players in the legal sphere. Their inclusion signals their significance, their potential to influence the outcome of the Illinois suppressor lawsuit. It's like shining a spotlight on recent victories against certain restrictions, suggesting that they might set a precedent for similar cases elsewhere. Their acceptance into the Illinois case isn't just a casual nod, it's a recognition of their potential impact.
Fitted with a suppressor to kill 12 Americans in Virginia Beach.
State lawmakers are considering several changes to gun laws, including making these much easier to get.
These rulings are being cited as persuasive evidence, saying, hey judge, look at what happened in California. Those decisions against certain restrictions, they could guide our way here in Illinois too. Their presence in the courtroom isn't just for show, it's a beacon of hope for those fighting against suppressor bans in Illinois, suggesting that recent victories elsewhere might just tilt the scales in their favor. It's like planting a seed of possibility, hinting that these decisions could influence the judge's perspective and shape the outcome of the Illinois legal battle. The judge's acceptance of these supplemental authorities isn't just a routine legal step, it's a significant development that underscores their potential impact. So, as the Illinois case unfolds, the inclusion of these California decisions isn't just a footnote, it's a narrative thread that could weave its way into the final judgment. Their acceptance signifies a willingness to consider how recent victories against firearm restrictions might hold relevance and influence the course of the Illinois suppressor lawsuit, offering a glimmer of hope to those advocating for broader firearm rights. Potential ripple effects. Picture this. The Illinois suppressor case reaches its crescendo, and the judge's gavel falls in favor of overturning suppressor bans. What happens next? Well, that's when the legal earthquake starts sending seismic waves across the nation, potentially reshaping the landscape of firearm rights. A favorable outcome in the Illinois case against suppressor bans could trigger a series of domino effects with far-reaching consequences. First off, it's not just a win for the folks in Illinois, it's a victory that could echo far beyond state lines. This decision could become a guiding light, a legal precedent that says, hey, if it worked in Illinois, it could work elsewhere too. Imagine it as a legal blueprint. Lawyers and advocates in other states facing similar suppressor bans.
The state house still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
How much louder is it without the silencer?
It's about 6 times louder without the silencer.
Might point to the Illinois decision, saying, look, this ruling sets a precedent. It challenges the notion that suppressors aren't protected under the Second Amendment. It's like using a torch to light up a path, showing that bans on suppressors might not stand the test of constitutional scrutiny. And it's not just about suppressors either. The ripple effects of this decision could extend to challenges against other restrictive firearm laws. It could bolster the broader fight for Second Amendment rights, creating a legal landscape where victories in one jurisdiction become ammunition for battles in others. This decision could become a tool in the arsenal of those fighting against unnecessary restrictions on firearm accessories. It's like opening a door to a new legal avenue, suggesting that the right to own and use suppressors might be more firmly protected than previously thought. But remember, this is all speculation until that judge bangs the gavel and makes the call. A favorable outcome in the Illinois suppressor case isn't a guarantee that bans in other states will fall like dominoes. However, it's a catalyst, a potential game changer that could set off a series of legal challenges and pave the way for broader recognition of suppressor rights across the country. That's all for this video, folks. We'll see you next time.